Hi guys, it's Kathy. I hope you're doing well. Do you like my new background? I hope so because you're about to not see it anymore. Because I tried to add a different background. So, of course, I don't have a background or a camera now. So, I will be desperately trying to fix my items while you guys are watching this. Guys, this is cool. This is really cool. We don't see this often. This is he committed a crime and his defense is reason of insanity. We should see that more often because listen, there's a lot of insane people here. I mean, America is chock full of them. We should see not guilty by reason of insanity probably 3 times a day. But no, we don't. So this one, I mean, we don't get to, he's not going to go crazy in court, okay? It's the lawyers arguing reason of insanity, and neither of the lawyers argue that hard. They both roll right over. You'll see. You'll see what I mean. While I try to fix my stuff, you guys can enjoy this. Here we go.
There.
Yes, I am, Judge. Thank you.
Good afternoon. Are you ready to begin?
Yes, I am. Thank you.
We'll call 23 CR 925, People versus Dimitri Crane.
Good afternoon, Your Honor. Kalina Cook and Josh Nathaniel for the people.
Good afternoon.
And Your Honor, Reina Montoya and Libby Bo on behalf of Mr. Crane. He is present in custody and in person.
Good afternoon. Good afternoon, Mr. Crane. We are here for trial based on the defendant's not guilty plea by reason of insanity. We are using the services of Ms. Hermosillo. A reminder, even though she's not here in the courtroom, she is reporting live virtually. Please stay as close to the microphones as you can. It matters less to me that you're sitting or standing or where you are than that you are close to a microphone, and speak as clearly and slowly as you can. Are the people ready to proceed?
Yes, Your Honor.
For the defense?
Yes, Your Honor.
What can we talk about before beginning trial?
Yes, the parties do have several stipulations. Prior to trial, Ms. Montoya did e-file that just a few minutes ago, but we have conferred and we are in agreement for all of those stipulations.
We'll take a look. I have reviewed the notice of stipulations of the parties filed with the clerk's office.
Speaking of insanity, you guys missed it. Bobby and me hung out for a while today. I kept streaming on Twitch, and I just was streaming while I was looking for content. And me and Bobby just hung out until my computer just crashed because I'm out of RAM. It was great. Thank you, Bobby.
On May 13, 2026, it will become an official part of the record once accepted. What else can we talk about before we begin?
Additionally, Your Honor, before we start, the people are moving to dismiss count 6, assault in the second degree, strangulation. We do not believe that there is enough evidence to proceed on that charge.
Any record there, Ms. Montoya?
No, Your Honor, we agree.
The motion to dismiss count 6, assault in the second degree, a class 6 felony is granted. Please follow up in writing at the conclusion of our hearing. I show 7 counts remaining, 1 through 5, 7, and 8.
Yes.
What else?
That's correct, Your Honor. Other than that, just a brief record that we are obviously proceeding with the bench trial, given the people have indicated that they are not contesting the opinions and findings in the Dr. Hatfield's report. Obviously, we're making decisions based upon that, and so I just want to put that on the record. I don't anticipate any issues there, but
I don't remember what our conversation was when we were here previously about waiving the right to a jury. Did I have a discussion with Mr. Crane about that?
I believe you did.
I believe so as well. And the confusion was whether or not the people had to agree or not. They were in agreement either way, but I think it's actually only for offenses before like 2022 or something like that.
In case someone else is looking at this down the road, do the people agree that these 7 charges should be tried to the court this afternoon and not to a jury?
Yes, Your Honor.
That's your request, Ms. Montoya?
Yes, and the statute does provide for an oral representation as well as opposed to writing.
That's Mr. Crane's wish today?
Yes.
Any further record on proceeding to a bench trial as opposed to a trial by a jury?
No,
No,
What else before we begin?
I think we're good.
I think that's it.
Happy to let you direct how you would like to proceed. Do you wish to make an opening statement? Would you like to go straight into evidence?
The people will forego an opening statement. We'll just go straight to our first witness, or our only witness.
Any opening statement for the defense?
No, Your Honor, we'll reserve.
And Your Honor, the people would call Officer Dane Henderson to the stand.
Good afternoon. Please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you will give before the court shall be the truth, whole truth, and nothing but the truth? I do. Please be seated. There is some water to your left. I believe you were in here when I mentioned that we're using a court reporter. She's on the computer. Speak as closely to the microphone as you can, as slowly as you can. Start by saying and spelling your first and last names.
My first name is Dane, D-E-N-E. Last name Henderson, H-E-N-D-E-R-S-O-N.
Ms. Cook.
Thank you, Your Honor. Good afternoon, Officer Henderson.
Good afternoon.
Would you please let the court know how long you have been a police officer with Denver Police?
A little under 5 years.
Right. And were you a police officer in February of 2023?
I was
What was your role at that time?
patrol officer.
And so does that include responding to 911 calls for service?
It does.
I'm going to jump right into this. Were you on duty early morning hours of February 14th, 2023?
I was.
And you got a call around 12:30 in the morning. Do you recall where that was to?
Yes,
Was that 27?
it was.
What did you know prior to arriving?
That there was a female screaming, and then they had actually updated the location to 27.
What happened when you arrived on scene?
When I got there, I seen a male standing at the front porch of 20. Upon walking up, I saw that he had blood on his hands.
Did he approach you?
I don't recall if we initially had approached him or not. I think we had asked him if he had called 911.
Did he attempt to flee at all?
No.
Okay. When you were contacting that individual, you said you saw blood on his hands. Is that right?
I did.
Did he say anything about that?
He had said that it was evidence, that it was his and another party's blood mixed together. He also made some statements about witchcraft and stuff like that, yeah.
Okay. Do you see that individual in the courtroom today?
I do.
Would you please point to him and describe an article of clothing that he is wearing for the record?
He's wearing a green jumpsuit.
Your Honor, let the record reflect the witness has identified the defendant subject to cross.
It will.
Did you ever get that individual, or did you get this individual's name?
I did.
Right. And what was the name?
Dimitri Crane.
And officer, when you were speaking with Mr. Crane, did he tell you any other details about what had just happened?
In that moment, I just remember him talking about the witchcraft and saying that she wanted, or the female part wanted to have him kill her.
Did he admit to attacking her?
He did.
Okay. Did he say this female party's name?
Emily Poley?
Okay. Did you speak with Emily Poley at some point in this night?
I did.
Okay. And you confirmed her identity?
Yes.
In reference to the witchcraft, what context was that given to you in?
So he had just said that he, after seeing the blood, he'd said that his neighbor or the victim was trying to seduce him with witchcraft, and that he wanted her to rape her and kill her.
Did he ask if you had ever dealt with witchcraft before?
He did.
Did you end up taking a statement from him after a Miranda warning?
I did.
And after the Miranda warning, what was it that he told you happened?
So he said that he made the same witchcraft statement, saying that the victim was making him try to use witchcraft to rape her and kill her, and that he'd had enough of it. He said he went to confront her at her residence, and that upon confronting her, she said she would not let him inside the residence. So he had broke a window and entered the residence forcefully to take her out, I believe were his exact words. And that eventually she had got away and he had tackled her in the backyard. And then she had ran to a neighbor's house, and that's where we contacted him.
When he said, take her out, did you ask a clarifying question about what he meant by that?
Yes.
And what was his response?
I think he said something on the lines like, I'm literally going to kill, and then he used a curse word, this person.
And so he was telling you that his intention was to kill her.
Yes.
And when he told you that he broke the window, is that right?
Yes.
Okay. And did he tell you whether or not he was armed during this?
Yes, he said he had a kitchen knife.
Okay. Did he mention a struggle between the two of them?
Yes.
Was your body cam footage on, or was your body camera on your person and recording during this?
Yes,
And did you review it in preparation for trial?
I did.
I'm holding up to you what has been marked as People's Exhibit 1. Can you see it from there?
Yes,
Okay. Is this the video that you reviewed in preparation?
it is.
All right. And was this in fact, the body-worn camera footage from this night and your interactions with Mr. Crane?
Yes.
At this time, Your Honor, the people move to admit People's Exhibit 1.
Any objection or voir dire?
No, Your Honor, and just for the record, the people have provided us with a copy of Exhibits 1 through 22. We have no objection to any of them.
Exhibit 1 is received, may be published.
And Your Honor, the people don't intend to publish exhibits today. We will just provide it to the court, if that's okay.
Thank you.
And Officer Henderson, did you also review several photographs that were from this night?
Yes.
Was one of those photographs a photo of the defendant when you arrived on scene showing the bloody hands?
Yes.
Okay. I'm holding up People's Exhibit 2 to you. Can you see that?
I can.
Okay. Is that the screenshot you reviewed?
Yes.
Okay. At this time, Your Honor, people move to admit People's Exhibit 2. I believe this is all stipulation.
By stipulation, 2 is received.
And so initially, Mr. Crane told you that he went to Miss Pulley's house. Is that correct?
Yes.
Okay. And that is at,
Yes.
okay. And when you arrived, he was standing outside of the home of 20 Denver. Is that right?
Yes.
Okay. Are those two locations very close to each other?
Yes.
All right. And did you look at a map beforehand that shows the distance between those two?
I did.
Okay. And was it a fair and accurate representation of that?
It was.
Okay. I'm holding up People's Exhibit 3. Is that what you reviewed?
Yes.
Okay. People move to admit People's Exhibit 3.
3 is received by stipulation.
When you pat Mr. Crane down for weapons earlier before handcuffing him and bringing him to the police vehicle, did you find anything on his person?
Yeah, my partner had found a bloody knife handle.
Okay. Just a handle?
Just the handle.
And on scene, was the blade of that knife ever located?
Yes, it was.
And do you recall where that was?
In the backyard of 1901.
And did you review several photographs that were photos taken by the crime lab of the scene that night?
I did.
And were those fair and accurate representations of the scene as you recall it?
They were.
At this time, Your Honor, the people would move to admit People's Exhibits 4 through 15, all scene photos that, and Officer Henderson, you have reviewed these prior, correct?
I have.
Okay, thank you.
All received per stipulation.
Thank you. And so in that backyard as well, near the knife, were there also some personal items found too?
There was.
Okay. Do you recall what those personal items were?
A robe, glasses, and a cell phone.
And do you know who those belonged to?
I believe they were the victims.
And the physical evidence on scene that is included in those photos, was that consistent with what Mr. Crane had told you happened that night?
Yes.
So you saw the broken glass on the front door
Yes.
and the struggle, it appeared that happened inside and outside?
Yes.
And then when you arrived at the entrance do you recall whose address that was?
Witness.
Right. Was that Gregory Ingram?
Yes.
Was he on scene as well?
He was.
And when you arrived,
The only thing that's annoying about this whole hearing is she didn't die. I know she didn't die. He tried to murder her. She got away. But they don't say what happened to her. Like, was it just a flesh wound on the arm? Or did he do damage? I don't know how bad his crime really was.
did it appear whether or not did it look like Mr. Crane was trying to gain entry to that home?
When I arrived, I didn't see him do that. I just saw him standing on the porch.
Did Mr. Ingram give a statement in this case?
He did.
Right. Did he indicate whether or not Mr. Crane was attempting to enter that home?
He did.
And what did he say?
He said that he had heard the victim scream. Upon looking outside, the victim came up to his door and came inside. And then the defendant had ran up and tried to push his way into the residence.
Okay. When you spoke with Miss Poley this night, how did she seem?
Scared, crying, kind of like terrified.
And did you speak to her before she went to the hospital?
I did.
And were you able to see some injuries on her as well?
I did.
And did you also review photos of her injuries that were taken in connection with this case?
I did.
And in preparation, did you review People's Exhibits 16 through 22 of those injuries?
I did.
Your Honor, at this time,
We need two more things in this world. We need more witches and more hippies. Remember, guys, remember in the 70s, which I don't because I was too young, so I missed out. But like hippies were just a huge group of people that loved everybody and everything was okay and just happy and loving, and they're gone. Like, you don't see huge groups of people that just love everybody anymore. Everybody just hates everybody. You have to pick a side right now. Everybody has to pick sides. There's 70,000 different sides, but you can only pick one of them. And then we also need, what did I say, hippies, and what was the other one? Witches. We absolutely need more witches. 100%. I mean, I need a herbalist badly because I don't get health care. And there's no herbalist. It's all like, or a hippie witch. That would be great. A large army of hippie witches. Oh yeah, Bobby, a shit ton of cats. Like you shouldn't even be able to walk down the street without tripping over 3 or 4 cats. And you should not walk down the street with having fish, because then you give the fish to the cats as like an offering. Here, thank you. Now go get your witch to get me some herbal remedies. That's what we need. Or now I'm probably going to get arrested and have an insanity defense.
People move to admit People's
No, she's
Exhibit
not.
16 through 22.
Received by stipulation.
Yeah, but they lovingly did it.
Officer Henderson, the injuries that were on Miss Poley, what kind of injuries were those?
Like multiple abrasions and scratches, a couple lacerations to her hands and arms.
Did those abrasions and lacerations appear to be from the knife blade that was found in the yard?
Yes, they were consistent with the story.
And was there also blood found on that knife blade?
Yes.
And Mr. Crane admitted to you that he used a knife in this incident.
He did.
Just one moment. Did Mr. Crane ever tell you whether or not he actually gained entry into Miss Poley's home?
He did.
Okay. And he said he did gain entry?
He did.
Okay. By breaking the front door window?
Yes.
And is that when he...
Speaking of hippie witch, Martha, we need you. Martha, we need you cloned like 1 billion times. We need a whole big groups of you walking around.
tackled her?
Yes.
Okay. And then at some point in this scuffle inside, was she able to get away from him?
She was.
And did he tell you that he followed her out?
Yes.
Right. And this was into the backyard?
Yes.
And then did he tell you that he tackled her there as well?
Yes.
And that another fight ensued between the two of them?
Yes.
Or an attack? And then did he say she was able to get away at that point as well?
Yes.
Okay. And that's when she ran to the neighbor's house at 2728 North High Street, correct?
That's correct.
And throughout your conversations with him about what happened on this day, what was his reasoning for why he did this?
He continued to talk about witchcraft and said that he'd had enough of her doing that to him.
Did he speak about voices that may have told him to do things as well?
I don't recall.
Okay. But mainly his reason for this was because he believed she was doing witchcraft on him.
Yes.
And
I know I told you guys before, but some of you may not have heard it. I was this close to being fired once because because the night shift person said that I was performing witchcraft on her. so all right. My husband left me. My youngest was 8 months old, and then just like add 2 years. Right, so I got 3 kids, and I was a stay-at-home mom because the job I had worked at before I started having babies was a press room with huge printing presses. Okay, so you can't work on a printing press while you're pregnant. It's dangerous. I mean, it's really dangerous, and the chemicals involved, not okay if you're pregnant. So I got pregnant the first time, and in that place you worked 9 hours or 12 hours. Like I worked 42 days in a row, 12-hour shifts, no one blinked, right? So I got pregnant once. Someone had to cover me for 10, 11 months, whatever it was. It wasn't that long. As soon as they found out I was pregnant, boom, I was off the line. People had to cover me. They did. They didn't like it, but they did it. Then I got pregnant again, and boom, I got fired for not following safety procedures. That's a different story, right? So then I was working from home. I was making websites, selling websites. I wasn't in IT back then. I was using templates and stuff. and I was just earning an income by building websites. Like my biggest customer was a jeweler who paid me $10,000 every quarter to update hundreds and hundreds and hundreds of pieces of jewelry on his website. So I did that. Then my husband left me, and that was the only income I had, but we were a team. He would go out and sell, and I would build. Once he left, I didn't go out and sell. I had 3 kids at home. So I got this part-time job quickly in this little drywall company. And from there, I started taking, I got 2 jobs. I got that job, and then I got a full-time job, and then I started going to college at night. So I got a degree. And right before I was done with my bachelor's degree, I got my first IT job. It was IT help desk, an hour away. I had to drive an hour away. I had to be there at 4 a.m. to relieve the night shift girl. So I get there at 4 a.m. every day, and like I did a ton of work. Like I was really good at my job. Well, because I was so good at my job, she who had way more time than me because she was on midnight shift, she looked really bad. There was nothing I could do about it, right? She told my boss I was doing witchcraft on her, and I was casting spells on her. And she was there way before me, but I did much more work. But she had seniority, so my boss called me and he's like, yeah, well, you know, I got some complaints about you. I'm like, what are you talking about? What complaints? I was doing a really good job. You don't even understand. And he's like, yeah, I'm told that you're performing witchcraft. The reason why is because I made a joke one day, and I can't remember now. It was so long ago what it was, but I just said something like, yeah, somebody was going to send a phone in or a computer in so we could fix it. And I said, yeah, maybe when Neptune crosses Venus or something like that. I said 2 planets. Boom. She that was way too much for her to hear. That I said 2 planets. So he almost fired me. He didn't. I asked him nicely, please don't fire me. I mean, I'm working hard. I won't perform any witchcraft. And then he didn't, and then she got mad and she quit, which was good because they put someone competent in her spot, and then we both did a lot of work and it was much easier. But yeah, I almost lost a job for performing witchcraft on someone. So they were huge printing presses. They were. And it's not code for anything else because nothing else in there was huge. I know, I married one of them.
This all occurred in Denver in the state of Colorado.
It did.
Okay. Okay, thank you. No further questions at this time.
Thank you, Ms. Cook.
I know I wasn't on mute because you were talking about printing presses. What, did you read my lips?
Cross-examination.
We don't have any cross-examination, Your Honor.
And unfortunately, I paused the video and I told a story, which means all the viewers that we had this stream freaking left. Sorry, guys. That was my bad. I can't help it. I like talking sometimes.
Thank you. May this witness be excused?
Yes, with our thanks.
Officer Henderson, your first name is D-E-N-E?
D-A-N-E.
D-A-N-E. Thank you. You may step down. Next witness for the people.
Your Honor, at this time, the people rest.
Any opening statement on behalf of the defendant?
No, Your Honor.
Any evidence on behalf of the defendant?
Your Honor, only the evidence that we have stipulated to in the notice, which is requesting of the court to take judicial notice of the evaluations and the opinions within the evaluations.
Any rebuttal case on behalf of the people?
Oh, I think the court needs to likely do a courteous advisement.
Oh, yes.
Yes.
Monica, please say I said thank you for the cheers. I saw it. Thank you for the cheers in case I didn't. I'm so sorry. I saw it. Thank you for the cheers.
Perhaps I've gotten ahead of myself. Are there any motions here at halftime on behalf of the defendant?
Given the stipulations, no.
And Your Honor, may I approach with the exhibits?
Yes. Mr. Crane, we're going to have a
V. Bren has great stories, I bet, if YouTube would let him type them out. Stories that would make our hair curl. But also, V, I also think you have some great stories that would make our hair curl.
conversation about rights you have with respect to testifying in this case. You're welcome to do whatever is most comfortable for you. If you'd like to stay seated, you can pull that microphone a little bit closer. You're also welcome to go to the podium. I don't know if your lawyers want to weigh in on that or what would be most comfortable for you today.
I choose to remain silent, Your Honor.
A different.
Oh, yes, I do. Oh, I choose to sit.
That's fine. We're going to have a discussion about rights that you have. First, say your first and last names.
Dimitri Crane.
Are you the defendant charged in this case?
Yes, Your Honor.
You are on trial for 7 counts. You, in this trial, have a right to testify. If you want to testify, no one can prevent you from doing so. You may take the witness stand, as you saw Officer Henderson do, and testify even if it is contrary to the advice of your attorneys. If you choose to testify, then Ms. Cook and Mr. Nathaniel will be allowed to cross-examine you, which means they would be able to ask you questions. If you have been convicted of a felony, the prosecutors will be entitled to ask you about those convictions and thereby disclose the fact of those convictions to the court. Is it correct that he has not been convicted of a prior felony?
That's correct.
Are there any other impeachable offenses?
I do not believe so, no.
There are no known felony convictions on your record and no other offenses that could be used to impeach your credibility. If a felony conviction is disclosed to the court and considered by the court, then I would consider that only as it bears on the issue of your credibility and for no other purpose. You also have the right not to testify. If you choose not to testify, I would not draw any inference of guilt from the fact that you chose not to testify. The decision of whether or not to testify is a decision that you must make and you alone. Your attorneys can't make it for you. Have you discussed whether or not you wish to testify with your attorneys?
No, Martha, you
yes, Your
are.
Honor.
Do you need any more time to talk to them about your right to testify or not to testify in this case?
No, Your Honor.
I want to remind you that even if your attorneys have advised you to testify or not to testify, you must make that decision yourself. Have you made a decision whether to testify or not in this case?
Yes, Your Honor.
What is your decision?
I wish not to testify.
No.
Are you making this decision yourself?
Damn it. Why can't he testify? I just wanted to hear him testify. It's all I wanted.
Yes, Your Honor.
Is it a voluntary decision not made as a result of pressure, influence, or coercion?
It is a voluntary decision.
Is anyone forcing you to make this decision?
Oh, no.
Is anyone pressuring you into making this decision?
No, Your Honor.
Is anyone coercing you into making this decision?
No, Your Honor.
Do you have any questions for me about your right to testify or not testify in this trial?
No, Your Honor.
Do you feel like you understand your right to testify and your right not to testify and the consequences of both?
Yes, I understand my rights, Your Honor.
I know
How
you
old are
will.
28.
How far have you gone in school?
I've completed college.
Are you taking
True
any
metal.
prescribed medications in their prescribed doses today?
Yes, Your Honor.
Have you taken any pill, drug, or alcohol in the past 24 hours?
Just my medication from last night.
In its prescribed dose?
Yes.
Do you have any mental, physical, or emotional conditions that affect your ability to think clearly today?
I was diagnosed with schizophrenia, Your Honor.
How does that impact your ability to think clearly during our trial today?
It impacts my ability to follow along or understand sometimes.
Are you having a difficult time understanding me so far today?
I'm aware now, Your Honor. So I believe
Maybe if you talk a little slower, Judge. I think you talk way too fast.
I'm understanding completely fine.
Any further record on the defendant's courteous advisement from the defense,
No, Judge.
from the people?
No, Judge.
I will find that your decision not to testify today is being made knowingly, intelligently, and voluntarily. What else for the defense here at halftime?
Nothing at this time.
Any rebuttal case on behalf?
No, it's halftime. Where are the cheerleaders? Where is the band? Where's the show? I want to see the halftime show in your courtroom, Judge.
Half of the people?
No, Your Honor.
The people rest. Closing statement on behalf of the people.
Your Honor, the people don't intend to make a closing statement unless the court has any questions. We're happy to answer any questions the court may have.
Should have said closing arguments. Any closing argument on behalf of the defense?
Unless the court needs to hear it, I obviously know the court knows there's a presumption of sanity unless there's evidence.
What's that one where you fall asleep all the time? You just fall asleep, neck. Great. Someone's going to remember what it is and type it. That's the one I want. I just want to fall asleep, whatever. Someone's talking to me.
That has been introduced, that evidence has been introduced, and our understanding is that people are not contesting that. So unless the court has additional questions or requires additional information, we have nothing more.
Narcolepsy, that's what I want.
On behalf of the people?
The people are in agreement with defense. We have nothing further.
Just one moment. We are here on the trial of Mr. Crane on counts 1 through 5, 7, and 8. The court will make the following findings of fact, conclusions of law, and orders based on the evidence before it. On May 8, 2025, Mr. Crane pled not guilty by reason of insanity. He was advised, and an evaluation of his sanity was ordered as required by CRS 16.8.103.7. The court received the report as required by statute dated September 8, 2025. It was prepared by Dr. Joshua Hatfield from the Colorado Department of Human Services. At that time, Dr. Hatfield opined that at the time of the alleged offenses in this case, Mr. Crane was legally sane. Subsequently, Dr. Hatfield filed an amended sanity and mental condition examination on February 16, 2026. In that report, he found that the defendant was competent and that, in his opinion, at the time of the offenses, the defendant was insane. As required under CRS 16.8.105, the court then set the matter for trial. Mr. Crane has waived his right to a jury trial. The court and the district attorney consented to that waiver. On behalf of Mr. Crane, the defense reaffirmed the defendant's waiver of his right to jury trial before we began today. After considering the evidence in the record, I will make the following findings regarding the case. Before discussing the evidence in the court's findings, the court notes that because Mr. Crane has raised the affirmative defense of insanity as to the counts charged in this case, the court is required to make a preliminary determination as a matter of law that credible evidence of the defendant's insanity at the time of the commission of the offenses has been introduced. Once this determination is made, the presumption of sanity no longer exists. The burden of proof is then on the prosecution to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the crimes charged. Thus, the prosecution must prove beyond a reasonable doubt that the defendant was sane, as well as all of the elements of the crimes charged. The court must consider the issue of the defendant's sanity with respect to each crime charged. When the affirmative defense of not guilty by reason of insanity has been raised, the trier of fact shall decide first the question of guilt as to the felony charges before the court. That's set out in CRS 16.8.105.53. If, after considering the evidence concerning the defendant's sanity with all the other evidence in the case, the court is not convinced that the prosecution has proven the defendant's sanity at the time of the commission of the crimes charged beyond a reasonable doubt, the defendant must be found not guilty. When the court sits as the trier of fact, it shall enter appropriate specific findings with respect to the affirmative defense of not guilty by reason of insanity. If alternatively, the court finds from the evidence that the prosecution has proven all of the elements of the crimes charged, as well as the defendant's sanity beyond a reasonable doubt, the defendant must be found guilty of these offenses. Pursuant to CRS 168101.5, which applies to offenses committed after July 1st, 1995, the applicable test of sanity shall be a person who is so diseased or defective in mind at the time of the commission of the acts as to be incapable of distinguishing right from wrong with respect to those acts is not accountable, except that care should be taken not to confuse such mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions. For when the acts are induced by any of these causes, the person is accountable under the law. Or a person who suffered from a mental condition of mind caused by mental disease or defect that prevented the person from forming a culpable mental state that is an essential element of the crimes charged, but care should be taken not to confuse such mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives, and kindred evil conditions, because when the act is induced by any of these causes, the person is accountable to the law.
I don't know, but it sounds like the judge might be using witchcraft, right?
A diseased or defective mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Mental disease or defect includes only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality and that are not attributable to the voluntary ingestion of alcohol or any other psychoactive substance, but does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. If the defendant is found not guilty solely by reason of insanity of any offense, the court shall commit the defendant to the custody of the Department of Human Services until such time as the defendant is found eligible for release. The executive director of the Department of Human Services shall designate the state facility at which the defendant is held for care and psychiatric treatment. The court has received by stipulation and considered Exhibits 1 through 22. The court has heard testimony of Denver police officer Dane Henderson. The court takes judicial notice of its file. The court also accepts and approves, adopts and approves the notice of stipulations of the parties filed on May 13, 2026. The court first makes a preliminary determination as a matter of law that the credible evidence in Mr. Crane's insanity at the time of the commission of the acts has been introduced based on the evaluations dated September 8, 2025 and February 16, 2026. With these evaluations, the court finds that the presumption of sanity no longer exists. The issue then before the court today is whether first, the people have proven that Mr. Crane committed the crimes charged, and because the defense of not guilty by reason of insanity has been raised, whether the people have also proven that Mr. Crane was sane at the time of the commission of the offenses. After considering the credible evidence presented to the court today, the court's file the stipulations of the parties, Exhibits 1 through 22, and the testimony of Officer Henderson, the court finds that the people have met their burden of proving beyond a reasonable doubt that Mr. Crane committed each and every elements of counts 1 through 5, 7, and 8. However, Mr. Crane is not guilty of the crimes charged because of the affirmative defense of not guilty by reason of insanity at the time of the commission of the crimes. The court finds that there is no persuasive and credible evidence before it that Mr. Crane was sane at the time of the commission of the crimes. Rather, the court finds that the undisputed evidence in the record is that Mr. Crane was legally insane at the time of the commission of the crimes as defined under the law. Regarding the crimes charged, the people proved beyond a reasonable doubt that the defendant, Mr. Crane, committed count 1, criminal attempt to commit murder in the first degree, count 2, first-degree burglary, count 3, first-degree burglary, count 4, second-degree burglary, count 5, assault in the second degree, count 7, criminal attempt to commit second-degree burglary, count 8, menacing. In reaching this conclusion, the court has reviewed and finds credible and has placed significant weight on the reports prepared by Dr. Hatfield. Most importantly, the second report, the amended report filed on February 16, 2026. Regarding Dr. Hatfield's reports, the court finds that the observations, investigation, and opinions reached by the doctor are both helpful and credible. The court adopts both reports in their entirety into its findings here. Specifically, the court notes that Dr. Hatfield indicated in his amended report that the defendant expressed a belief that God had sanctioned his actions, that Ms. Poley told police that the defendant appeared to believe his actions were acceptable, that the defendant remained at the scene shouting at a neighbor, trying to convince the neighbor that Ms. Poley was not a good person, that Mr. Crane did not attempt to hide the weapon or clean up any blood on his person or elsewhere, that Mr. Crane did not run from the arresting officers, that Mr. Crane appeared to believe others, such as the arresting officers, would side with him if...
No. That doesn't mean he's insane. Cleaning and running is just too exhausted. There's no way I'm going to do that. And I'm not insane.
They understood that he was being spiritually attacked. At this time, the court finds that there is more evidence than not to suggest that Mr. Crane was insane at the time he committed the charged offenses. With that, I will find the defendant not guilty by reason of insanity by a beyond a reasonable doubt as to counts 1 through 5, 7, and 8.
Holy shit, Monica, you're pregnant?
No judgment of conviction will enter. Is that the correct next step?
It is, and I don't think we even need to talk about murder or anything of that nature, given that.
Because he was found not guilty by reason of insanity. How would you like to proceed now?
I think the court commits Mr. Crane to the State Hospital of Pueblo, and I think that we set a review within
120 days.
120 days.
I'm sorry.
And the court also, I think, needs to order a release exam of Mr. Crane.
We are at a critical stage under the Victim Rights Act. Does any victim or their representative wish to be heard? I don't recall seeing a victim impact statement in the court's file.
Your Honor, we were able to connect with Ms. Poley. We explained how this was going to happen, and she intended to be here today. However, since she is on the East Coast, she got her time zones mixed up and ended up not being able to be here. But she did not want to express anything to the court. She didn't have any requests to move anything around. She just asked for an update afterwards. So the people believe that the VRA has been satisfied. And one moment, because I just want to check something. I believe I may have a victim impact statement that she wrote
Bitter's fine if you use a little Vegemite with it.
quite a long time ago, back in 2023. Just make sure it's not just. I do have a victim impact statement from 2023. It's March 8th, 2023, so pretty close in time to this offense. If the court would accept that, I'm unsure if defense has seen this or not. We are printing it now.
Is there a Bates stamp, Ms. Cook?
There, the folder I have it under is restitution, so there's not, but it should.
I guess, is the court asking for the victim impact statement to be read? My understanding is that the victim is not wishing to be present or to relay any information to the court.
I just asked if anyone wanted to say anything here at a critical stage as provided by the Constitution, and I'm happy to hear from anyone in whatever form you would like
I think
to
our
do that.
request would just be that the court receive this. I think it's probably already in the record. I'll provide it to defense. We're not asking to read it aloud.
Thank you. I don't see it in the electronic court file. Please upload it when we're finished with our hearing today. Is this a juncture where it would be appropriate to ask the defendant if he would like to say anything? Or
Is this a juncture where it would be appropriate to ask if maybe Sue Crisantho is doing a trial in October?
ask if there's anyone who would like to speak on his behalf? We're not at sentencing. I don't know, however, if you think that's appropriate.
I don't believe that there is a requirement that the court do that. If the court would like to, we're happy to speak with Mr. Crane. I can tell the court that his mother, Ms. Crane, Sheila Crane, is present in person. Right. Right, yeah, no, sorry, Your Honor, I was just going to advise the court that his mother is present. She lives in the state of Florida and has traveled for several of his court appearances, including the one today. I don't believe that we're asking the court to consider any statements today.
Thank you. Based on my findings, I am required under CRS 168105.5 to commit you, Mr. Crane, to the custody of the Department of Human Services until such time that you are found to be eligible for release. The Executive Director of the Department of Human Services shall designate a state facility at which you will be held for care and psychiatric treatment and may transfer you from one institution to another if, in the opinion of the director, it is desirable to do so in the interest of your proper care and treatment or the protection of the public or the personnel of the facilities in question. I will issue a written order to that effect on the form that is provided for those purposes. Your request is for a date in 4 months, is that correct?
I think we have a few requests, Your Honor. The first is, yes, I believe the court must schedule a hearing within 120 days per statute.
And that to me is crazy. That's more crazy than he was. So he's insane. The doctors say so. The judge just said so. Okay? So he's not going to be charged with this crime of attacking her. Attempted murder is the charge. He's going to an insane asylum or mental hospital, and they want a hearing in 120 days. They have to have one within 120 days to see if he's been fixed and is no longer insane, so they can release him. That's the whole reason for the hearing.
The second request is that the court should order or shall order the Department of Human Services to complete an examination, a release examination, no later than 30 days prior to that hearing. And then the last thing that we are requesting, Your Honor, is that the court, within the order of the release examination and the commitment order, that the court make a referral to the forensic community-based services. We have been speaking with some individuals from the state hospital about how best to get Mr. Crane in services quickly. They do that generally in terms of connecting people with the forensic community-based services. However, we were told that something in the minute order or an order from the court would be helpful in expediting that.
Ms. Cook?
Nothing from us on this, Your Honor.
How is 120 days is September 10? How is September 3rd?
I do love salty.
Either of those dates work for me.
But I do love chocolate. Chocolate makes me feel better. It's medicinal.
Ms. Bova and I are both available on the 3rd and the 4th. I don't know if the court wants to schedule this for Friday afternoon, given that it's going to be scheduled for a hearing.
I've seen a handful of these done, and I've never experienced a hearing this quickly. In the past, what we've done is schedule it for a hearing pursuant to statute, and the parties have communicated ahead of that hearing date. And our understanding has been, in the unlikely event that it went to hearing, we may actually ask for a date that worked for evaluators, and we would confer about our schedules and sort of set a date that works with the court's calendar and everyone else's calendar in the event that a hearing is appropriate. But I've never seen one after 4 months actually happen. You've seen one?
It's up to Your Honor and the court's docket. We are available both days. I think if in the event that there's no evaluation or there's a stipulation or there's something that needs to be moved, it can be moved, but.
Happy to set this at 1:30 on September 3rd. We can set it at 1:30 on Thursday, September 10. The day before Labor Day, that Friday before Labor Day, I'm not going to be around.
Yeah. With my math, the 10th, September 10th is the 120th day. So just in case there are some issues, I think the 3rd would be better.
Set it at on Thursday, September 3rd at 1:30.
Defense can accept.
That will be for receipt of a report from the state hospital. Is that correct?
No, it should be set for a hearing, a release hearing.
Set for.
The receipt of the report should be 30 days prior to that hearing.
There should absolutely not be any kind of release hearing in 120 before 120 days. There just shouldn't. Days should not be on the end of that frickin' sentence.
Set for hearing. Report due 30 days in advance of that hearing. The minute order will reflect a referral to the Forensic Community-Based Services Office at the state hospital. What else can we talk about today?
Judge, I think we need, if possible, if the court can reflect Ms. Montoya's co-counsel on this case. I think we have tried to do that in the past, and for some reason, she's still not getting served
on e-filing.
So
I'll ask,
We will remain Mr. Crane's counsel, and I just want to make sure she's getting everything I'm getting.
we'll ask Mr. Sherry to include Mr. Nathaniel and Miss Montoya. What else?
We have nothing further, Your Honor.
Nothing from us.
Please upload.
So there we go. We just went through an entire insanity defense hearing. That's what happens. It's crazy, isn't it? Sorry. Sorry. Now let's go to a love story. Let's bring Love into the chat.
Thank you, sir.
You're welcome. Mr. Pauls, did you see the video describing your rights?
Did you see that video?
Yeah.
Any questions for me about your rights?
No, sir.
Okay. The charges you're facing here include second-degree assault with
I know, Crystal, but I don't think he will be. I just don't. I have faith in the doctors that they will not let him out in 120 days. I have faith in the doctors.
injury with a deadly weapon and second-degree assault with intent to cause bodily injury by strangulation. Each are Class 4 felonies. 1 to 12 years in the Department of Corrections, followed by parole, a fine between $2,000 and $500,000. Third-degree assault, physical
Do you see him blowing kisses at her? Yep, that's what he's doing.
harassment for following somebody, and third-degree assault knowing a victim is pregnant. Each are up to 364 days in jail, a fine up to $1,000. The knowing victim third-degree assault is a mandatory jail sentence. If convicted in this case, you'd be required to complete domestic violence counseling. You could also be ordered to surrender any firearms or ammunition in your possession within 24 hours. Do you understand that, Mr. Pauls?
Yes, I do.
Ms. Shisham, Mr. Brady?
It applies, and I believe
I have to know before we go any further. Did anybody catch his kiss? Anybody? Did anybody reach up and catch it? I'm just asking. I know one of you did.
Ms. Lieberman is pregnant and would like to address the court.
Okay. If you can come on up to the podium, please. I need you in front of the microphone there. If you could state your name and spell your last name, please.
My name is Rachel Liverman, and my last name is L-I-V as in Victor, E-R-M-A-N.
And what do you want to let me know?
I just wanted to kind of have my own opinion on the whole situation, because I do know that he has an extensive history, and I do understand the man I am with. But I'm asking you to look at me physically today and see that I have no strangulation marks, no assault marks, no bruises, no cuts or lesions or anything that would signify any kind of assault ever happened. And so I would be in support of obviously a PR bond. And I was hoping maybe I understand Colorado has to issue the protection order of no coercion, harassment, stalking, which are criminal acts anyways. So he's not going to do that, but I don't want a restraining order.
Okay.
I would advise you not to say anything.
Okay. Thank you.
Okay, thank you.
You're welcome. Ms. Shisham?
If I didn't already say it, Brady does apply. With all due respect to Ms. Lieberman's wishes, we are asking for a high cash bond in this case. Mr. Pauls has 5 felony convictions, 5 misdemeanor convictions. He scores as a DVSI of 11. The details in this case are extremely concerning to the people, that as she was trying to walk away from her, she's telling him not to touch her. He continues to advance. He hits her once on the right side before getting behind her, uses his left arm to place her in a chokehold around her neck and leans backwards. She puts both hands up towards her neck before Mr. Pauls uses his right arm to hit her again. Not only is that strangulation extremely concerning for victim safety, but there's also the aggravated fact that this victim is pregnant. The defendant is using drugs and angry by all accounts. In this case, the victim is living out of a car, and there is no way feasible to keep her safe if this defendant is released. We're asking for no contact with Rachel Lieberman, no firearms, weapons, or ammunition and relinquishment, no drugs, pretrial services, and testing.
Ms. Tebow?
I would be requesting a personal recognizance bond. Mr. Pauls scores as a category 2 on the CPAT. He has only one prior domestic violence conviction, and it's dated. It's from 2011, so about 15 years ago. He is originally from Grand Junction. He grew up here in Mesa County. He recently returned to Mesa County. And so when I was reading the CPAT, I was a little confused about the 2 months in the area. But from speaking to Mr. Pauls, he is from here originally. He grew up here, was living elsewhere for a while, but is now back. He does have ties to the area and family support. He has his mother, grandmother, sister, friends, uncle who reside here who are supports for him. Additionally, if released, he could potentially reside with either his grandmother, his uncle, Toby, his mother, or his sister. He is able to get to and from court. He can get rides to court, and he additionally has a bike as a backup plan. I would note that he has no prior failures to appear within the last 5 years. There are 9 within his lifetime, but they have not occurred recently. In terms of employment, he was doing some side jobs and temp jobs like cutting trees and was working on trying to find more long-term employment. He would like to get treatment, and so if the court's unwilling to just do a personal recognizance bond, then we would ask for a fast-track bond in the alternative.
Okay. Ms. Liverman, do you want to add something?
Yes, please.
Well, you have to be at the microphone.
I really do.
I've never heard of fast track bond before. I don't know what it means.
So, Your Honor, I don't know.
Get into contact with her.
Zane,
Yeah.
stop. I don't know what I can really, because when I went up to the DA's office to try to get this like dismissed this morning, they pretty much told me I can't talk about the alleged facts of this case, but they're not facts at all. It's literally all assumption, even in the affidavit. It's all assumption. It's just absolutely disgusting what they've accused him of on literally assumption. I even filed a motion to you hoping it would get in front of you and so you could have a chance to look at the affidavit because
Well, I looked at the affidavit.
it's disgusting. They like refer to me as a liar and then in the same sentence say, well, she did in fact run into the cupboard. That's what I was telling the cop the whole time I ran into the cupboard. He never assaulted me. I dropped down to my knees. I've had past domestic violence. You were the judge in that one too, actually. And so, I mean, like I might have a little PTSD and drop down to my knees. But in this case, it is like despicable what they make him out to be and the way they change my words, or they say that Nike, which was the cop I was personally talking to, they say that later relayed to me that Rachel denied anything occurring. She stated she accidentally fell into a cabinet and she was not even pregnant. In no way have I ever denied being pregnant. In no way. Okay. Then later on it says Rachel consistently lied and provided an inaccurate account of events. Who was there? It says then again that the cameras have a short time lapse, meaning the cameras have been tampered with.
These are all things, Ms. Liverman, that
In an affidavit.
they'll be litigated, and I found probable cause for the charges. I'm not going to argue probable cause.
I
with
could
you.
understand that. I'm not asking you to. I'm just asking you to like not see me as a victim right now because I promise you if I had been assaulted by that man, you would know and
Okay.
you would see it.
Okay. Thank you, Ms. Liverman.
Please don't say anything, okay? Your Honor, could I just have a moment and mute the microphone?
No, unless he's got a question for me.
I do got, may I ask a question, sir?
About what?
About the restraining order. Like this is the only support I have, like we've been.
I'll tell you what it
I would
is,
advise you
Mr.
not to
Bowles.
say anything.
I'll tell you what it is, okay? And then I'll ask you if you understand that. Okay? Court at this point will set bond of $5,000 cash only with pretrial services supervision. No harassment, molesting, intimidating, retaliating, or tampering with any victim or witness. If you violate that restriction, you could be charged with a separate case that could also be a felony. Until modified by the court, there's no contact with Ms. Liverman. You're also prohibited from possessing, purchasing, or attempt to purchase or possess any firearms, ammunition, or other weapons, and you're ordered to relinquish any of those that you do have. Do you understand those restrictions, Mr. Pauls?
So I have a no contact order with my wife?
That's exactly right.
So how can that get changed at all? This is going to ruin my whole relationship. I have a kid on the way and everything.
Please don't say things.
As long as the case is open, the court maintains jurisdiction to modify that. Until that's done by another judge, it remains in effect. So I'm going to give you the next court date for the case to be brought back for formal filing. That motion that you filed, Ms. Lieberman, will be in the file by that time. So Judge Lawrence can take a look at that.
Modified to electronic.
Not at this point, no. No. Case is assigned to Judge Lawrence. Can we bring it back next Tuesday?
Sure.
Ms. Shisham, that's the 19th.
That works.
Ms. Lieberman? That'll be at 8:45 in Division 10.
You said how much for cash bond?
5,000. Mr. Pauls, would
Hold
you
on,
like to
listen.
appoint the Public Defender's
Listen,
Office to
guys.
represent you?
Yeah, I'm fine with that. But I just have one more question.
Please stop talking. I will go out there and answer your questions, okay?
Well, I tried to ask you earlier, you didn't answer at all. Like, there's a motion.
I will come chat with you in a moment.
This is my wife. It's not just some, like, you know what I mean?
I love you though.
I love you too. I can't talk to you, but I love you.
Yeah, and that's including talking to her and telling her you love her on my recorded court appointment.
Well, I'm sorry about that, sir. I'm just, this is.
Well, be quiet. Quiet before you end up with more charges. Leave the room.
Thank you, Ron.
Anthony Wilson?
Bobby, this will sound familiar. Now you get to watch it. You get to
Mr.
see
Chevalier
the
appears in custody, in person with his attorney, Mr. Welch. Mr. Clark is present on behalf of the people. We were set for both a motions hearing today and a pretrial readiness conference.
You're here on.
Mr. Tomlinson, are you also appearing via WebEx?
Yes, ma'am.
Court would note that named victim, Mr. Tomlinson, is also appearing via WebEx. We were set for both pretrial readiness conference today and motions hearing. Mr. Clark, any record that you wanted to make?
Your Honor, I've moved to dismiss this case based on two things. One, I don't believe I have a prima facie case that I could present to a jury. There is, in my opinion, there would be issues as to who was the aggressor in the fight. And I also have a witness unavailability. Based on that, Your Honor, I had moved to dismiss the case for the.
This judge reminds me so much of that one judge from Washington State. I don't know her name though.
Let me make a record regarding VRA.
Previously, we had tried to contact. Well, anyway, Mr. Tomlinson is in DOC. And so what had happened at that prior, when I moved to dismiss the case, our notices and phone contacts and stuff, we didn't have him. Well, it was because he was in DOC. So Judge Roback set this.
How does he have a hat in DOC? How does he have a hat? Hi, PI.
Just continued this for me to try to get VRA out from Mr. Tomlinson. So we did arrange for him to be on the WebEx today. I'm sure he would disagree with my opinion, but he was brought here for VRA.
Mr. Tomlinson, any record that you wanted to make regarding?
Judge, no, please.
Or anything you wanted to say regarding the
No, Judge.
prosecution's record and request to dismiss?
Judge, I'm begging you, stop right now.
Let me make sure you're unmuted. Hold on, Mr. Tomlinson.
What's that?
Hang on.
Okay. What I'd like for the courts to know is I was not the aggressor in this first degree assault, in my opinion. I have a broken thumb from this incident. I mean broken. It ain't fractured or hairline fractured. It got looked at when I was on the streets out on bond after you gave me 10 years at DOC.
Mr. Tomlinson, I'm going to make it very clear. Hold on, Mr. Tomlinson.
You
Yes,
have the right and opportunity to talk about the dismissal in this case. It is not the time for you to make comments about the court's sentencing in your own case. Is that clear?
Yes, ma'am. No, I'm just saying that when I was on the streets, I went to get looked at by medical attention before I got sentenced to my case off of the streets out on bond. And I have a broken thumb. I mean, it is clear to see. And I mean, broken. It's bent. It's trashed. My pinky is broken. Okay. I ended up with a black eye and a bloody nose in this fight. He swung on me 3 times in front of the jail camera in C-Pod underneath the cameras. It is clear to see I ducked all 3 of them and had to do what I had to do in self-defense. We both ended up in the metal staircase. He got a swing on me, which I was denied. Okay, the cops came in 7-10 minutes later through this altercation, fight, or assault in my eyes. The cops swarmed in and they broke the fight up. They took me out. They stuck him in his cell. They later on stuck me back in my cell, denied me of medical attention. I was denied medical attention with a black eye and a bloody nose. Okay? They then moved me into my cell, made me stay in my cell for 5 days without any talking to any officers or anybody. All of a sudden, Mr. Wright, Deputy Wright, came into my cell, asked me if I wanted a asylum waiver. I said, absolutely not. I agreed to go to a hearing. I was never took to a hearing at all. Okay. Eric Chevalier was, then placed in his cell for 24 hours is all. I was placed in mine for 5. We were kept in the same exact.
How do you know? If you didn't speak to anyone for 5 days, how do you know he was only in for 24 hours in his cell? Because you would think that you're in your cell every day, right?
Odd, which is unlikely to happen in any county jail across the United States of America when an altercation like this happens or a fight like this happens. I was then later on sent a victims compensation fund packet. And I don't know why Miss DeHosa and George Clark, the DA.
The reason why he's so mad is because since they're not really allowed to fight in prison, they win arguments by thumb wrestling. And he loses every time now. Every time.
And Jeffrey M. Lindsay sent the packet to my mother's address, knowing that I was in the county jail. But it got mailed to my mother's address on 105. They knew I was in the county jail. I was in the county jail for 8 months, 9 months. I then bonded out with you lowering my bond, Your Honor. And I went and did what I had to do on bond. And when I filled out the compensation packet, it was left in your courtroom on November 14th with my lawyer, Tyler Jolly. Okay? And me and my son have never seen the packet, never talked to Mr. Jolly, who...
Do you remember in Judge Eric's courtroom, there's the prosecutor's Mr. Sunshine? I would love the defense attorney, Mr. Jolly, and Mr. Sunshine to get into an argument in front of Judge Eric.
Basically coerced me into accepting a plea on my other case and everything, okay? So I now need all footage of the video cameras and all that saved and be brought in back into court. I don't know how long you guys can continue this for, but it is real difficult. In the process in DOC, you have to fill out a phone list and get people's phone numbers and addresses okayed on your phone list before you can actually contact them, which takes sometimes several weeks. Okay. I'm going with Kilmer Lane and Newman up in Denver, 1543 Champa Street on this case, plus my other cases also. So I need the courts to do me a favor, and I need all body cam and video cameras, dash cams, and of this incident also.
It is impressive how he is spouting off addresses. he's going to spout off his case number right off the top of his head while he's arguing?
Mailed or faxed, however, to Kilmer, Lane, and Newman, which is my constitutional rights, civil rights attorneys. I know this has nothing to do, Your Honor, Ms. Swan, with my other cases, but I'm just letting you know that all these need to be saved because I'm not just letting this fly over with a broken pinky and a broken thumb and a black eye, denied medical attention. And then obviously George Clark himself knows, Your Honor, that something had happened to me or he would never mailed me a victim's compensation fund packet. Okay? This packet disappeared on the day that you sentenced me on my case number 24 CR 5029 to 10 years in DOC. The packet just like fell off the map out of your courtroom with my lawyer, Mr. Tyler Jolly, who wasn't much lawyer to begin with. So anyhow, I also mailed you a letter. I don't know if you got it. I'm hoping you did on my other cases on a motion for reconsideration. Because I haven't got anything back.
Now is not the time for that, Mr. Tomlinson.
Okay.
We are not discussing your own cases here. We are discussing this case.
Yeah, so if I can get I pretty much let the courts know exactly what happened. The courts as well know, I'm sure, that Mr. Eric Chevalier with 211 prison gang vibes president across the gut of his stomach leader is the one who assaulted me in jail.
Thank you for the goat. I love it. Thank you.
So I don't know how this could just be dismissed with all this victim compensation fund packet mailed to myself. And I haven't had a chance to go to court. And I think actually that the district attorney's office tried to scapegoat out of this little incident or this case by trying to contact me within 3 days of a notice of a court hearing when they know how DOC courts work, that they're within at least 14 days minimum to be notified.
All right,
So
Mr.
I don't
Tomlinson.
know how we need to continue this on further till I get a hold of a lawyer to go in court with me, because I'm not accepting another appointed defense counsel out of Denver like I did Mr. Jolly, who railroaded me in my case. So
and
I
she's
wouldn't do
done.
that in this case.
All right, Mr. Tomlinson, we're done. I've warned you several times about discussions of your own.
Yeah.
Stop arguing with me right now, Mr. Tomlinson.
I'm not arguing with you, ma'am.
I'm speaking, you're not.
Yes,
No
ma'am.
more. Is that clear? I've
Yes,
warned
ma'am.
you multiple
Yes,
times
sir.
about stop speaking, Mr. Tomlinson. I have warned you multiple times about not talking about your own case. The purposes for your statements today are as to this case and the dismissal motion by the prosecution for this case. So I've gotten a record from you on that. I am finding that that record is sufficient at that time. I'm not going to continue to give record time for you to complain about other cases. So I will be muting you at this time because I have received your position. What I will indicate is I am not granting a continuance on your request here. You do not have standing to request a continuance in this case. However, I am ordering that the prosecution comply with the VRA statute in regards to your request for records. And ultimately, there are other legal mechanisms for you being provided discovery from this case. Rule 16 under the rules of criminal procedure do not require that this court order for the prosecution to provide discovery in this case to a named victim. So I am denying that request through this case, but I am ordering the prosecution to continue to comply with the VRA statute and any obligations for providing records under the VRA statute. And certainly if you are seeking counsel for a civil case, they can pursue discovery actions through that case as well. Court is finding that the prosecution made a representation that they ethically cannot proceed forward in this case because the prosecution does not believe that they have a prima facie case in this situation. I am taking Mr. Clark's word as an officer of the court regarding that position, and I am granting the dismissal at this time. That being said, there are mechanisms through the Victims' Rights Act. Mr. Tomlinson, that you can pursue to review the motion to dismiss that is filed, but I am granting it at this time. Any other record at this time, Mr. Welch?
None from the defense.
Mr. Clark? That would resolve this case. I would vacate all future court dates for this case based on the record made by the prosecution and the granted dismissal at this.
I don't get it, but I mean, he did get assaulted in jail, so I don't know why they dismissed the case, but they did. And, you know, that's what happens sometimes. Let's do this one.
26 CR 459. Can you unmute them? Mr. Gonzalez, I just noted since they had you over there in Garfield County, did they advise you of your rights pursuant to the case that you have there in Garfield County?
We talked about his rights, Your Honor, so I think he's all set, and he's seen the video here before, so we went.
Any questions for me, Mr. Gonzalez, about your rights? You need to answer out loud, Mr. Gonzalez. You're.
Can you hear me, Connor? Can you hear me?
Yes, I can.
Hear me? Yeah. Thank you.
Any questions about your rights, Mr. Gonzalez?
No.
Okay. The charges in this case, 26 CR 459, based upon the warrant that was issued, includes second-degree criminal trespass, is up to 10 days in jail, a fine up to $300, obstruction of a peace officer is up to 120 days in jail, a fine up to $750, and criminal attempt to commit second-degree assault against a peace officer, a Class 5 felony, is 6 months to 6 years in the Department of Corrections, followed by parole, a fine between $1,000 and $100,000. Do you understand those potential penalties?
Yes, Your Honor. What's that officer being charged with?
Nothing, as far as I know. Ms. Shish,
Charge that officer. Charge him.
Mr. Bond.
Judge, we would argue that the bond is appropriately set. Mr. Gonzalez has at least 8 felony and 15 misdemeanor convictions. His recent criminal activity includes in 26M 629, a warrant for failure to comply on March 31st. In 25M 667, a warrant for failure to comply on April 23rd. In 25M 3531, a warrant for failure to comply the same day. This case occurred on May 10th, and then there was a new CR case in Garfield County yesterday. I couldn't see the charges.
Vehicular eluding.
I'm sorry?
Vehicular eluding.
Thank you, Judge. In this case, he almost hit a law enforcement officer with his truck and then fled, and then obviously committed a vehicular eluding yesterday in Garfield County. He would present as both a threat to community safety and a flight risk. We're asking for no contact with the Palisade Pool at 571 West 5th Street and pretrial services.
Ms. Heiserow?
Thank you, Your Honor. We're asking that the court consider a PR bond. Is the court not addressing your failure to comply warrants in the other cases?
No.
No?
No.
Okay. In speaking with Mr. Gonzalez, I think the court is well aware of Mr. Gonzalez and his history, as he has been in front of Your Honor for quite some time at this point. It's my understanding in talking to Mr. Gonzalez that he was on his way to go to rehab. He has a friend in Denver that was going to help him. I believe Amy, who the court is also familiar with, is a support for him as well, and she has been helping him in his goal towards getting into rehab. I think that the court is also aware that Mr. Gonzalez does have a fear of the police due to, I think, frequent arrests that he's had over the past year or so. And so I think that fear may have escalated any response that he had in this situation. I think that the officer pulled a firearm on him rather quickly into the interaction. And so we would ask that the court consider a PR bond. If the court is not willing to entertain a PR bond, we would ask that the court authorize a screening for fast track.
Court will set bond in this case, a reset bond to $25,000 cash only. Mr. Gonzalez, when confronted with me remanding him almost 3 weeks ago in my courtroom, said, quote unquote, "This is bullshit." Tried to go out the emergency exit upon leaving my courtroom. When the alarm sounded, he went to the right. Then he's basically absconded from his jury verdict. I've issued 5.
I've been on many dates like that. They sneak out the emergency exit on me.
warrants for failing to comply with pretrial services. The last I heard was that there was problems with testing. They were going to retest things for it, including the most recent test was the day after the jury trial on the DWAI possession of a controlled substance. I have absolutely no faith that if there's anything other than a high cash bond that Mr. Gonzalez will make it to court. I don't necessarily accept that in the nearly 3 weeks that he's absconded from the cases in my division that he was going to rehab. There's been no indication that he's had contact with counsel. No motions has been filed, and he's not checked in with probation.
Your Honor.
No going to the Palisade Pool at 571 West 5th Street is a restriction, as well as no harassing, molesting, intimidating, retaliating against, or tampering with any victim or witness in this case. If you violate that restriction, Mr. Gonzalez, you could be charged with another case that could be a felony. Do you understand that?
Yeah, I guess.
The case is assigned to Judge Flynn. We'll return it next Thursday, May 21st at 8:30 for formal filing.
Your Honor, will the district attorney be requesting a video writ for that? I think he's being held on the Garfield County case.
Ms. Shisham?
I don't know. I can
Okay.
look at it.
Okay.
Extreme prejudice in this case, and I'm requesting a change of venue entirely out of your courtrooms, Your Honor.
It's noted for the record, Ms. Gonzalez. Mr. Gonzalez?
Appreciate that, Your Honor.
Uh-huh.
Yeah. Refrain from possessing or controlling any weapons, firearms, or ammunition based on the allegations. It is not a relinquishment type case, not domestic violence, but with these allegations, I think it's appropriate to keep you away from weapons. I wasn't going to list the addresses, Ms. O'Hara, not that I know them. I just think it would be counterproductive in any event under these circumstances.
That's fine, Your Honor.
All right, bond argument?
Your Honor, the defendant appears to be on probation in 3 separate cases, 2 out of Weld, which are crime mischief and third-degree assault, and then another one out of Clear Creek.
That's not possible, because remember, when you go on probation, they say you can't break the law. So if they did break the law while they were on probation, then they would be in jail, right? So how could they pick up another case? That doesn't make any sense.
Harassment, those all were domestic violence related. He does have 2 prior drinking and driving offenses out of state, one in Idaho in 2015, one in California in 2012. Pretrials reserving judgment based upon the nature of the allegations, where it's alleged that there was an animal involved, which is kind of what started all of this. So that charge may eventually be added. But then with threatening the neighbors and the threats that he was going to basically beat them, and he was waving that object around, the people do, we are requesting a bond in the amount of $7,500 cash or surety. I'm requesting pretrial supervision at this point.
Thank you. Ms. Talbert?
Thanks, Judge. We are requesting a personal recognizance bond. Mr. Moore has indicated to me he's not able to afford any amount of monetary bond. I would note that the pretrial services bail report does place him in a risk category 1, and he only scored a total score of 4, so did score very low on that instrument. He has lived in the area for the last 8 years, and he does have a steady job. He works at Skyline Moving, so he does have strong ties here to the community as well.
I'd certainly take that into account. To be frank, I had it much higher than that. If someone has the audacity to turn their attention to someone whose dog is being hit, then they get threatened into the bargain. That is substantially disconcerting. and then substantial noncompliance with the officers. I'll go ahead along with the $7,500. I'll find that with pretrial services that is appropriate, although my starting point was higher than that. But a $7,500 cash or surety appear at all future court dates, comply with the protection order, do not possess or attempt to possess or control firearms, ammunition, or any other weapons, do not violate state, federal, or municipal laws. Return the charges May 13th at 3:30 in the clerk's office, May 21st at 3:30 out of custody. Once you have charges in hand, you can apply for or in custody request a public defender automatically. That'll be it for today. Thank you. People to comply with VRA, please.
Your Honor, next up I have John Vigil.
Thank you, Judge. I'm also ready on Christopher Rich from the 830 docket, 26 CR 896.
The court will call Christopher Rich. Case number is 26 CR 896. Good morning, sir. Come on up to the podium.
And Eric Johnson for the people, Your Honor.
And if you could state your name for the record, sir.
Christopher Michael Rich.
Thank you for being here this morning.
Thank you.
And what are we doing on Mr. Rich's case?
Judge, in talking with him, it sounds like he's trying to work with Florida. I don't think we've got a resolution on that yet. My plan here, I would just ask the court for another review date in a couple of weeks. I will check with my counterparts at ACSO about the status of Florida and whether they're seeking a governor's warrant or if there's any movement there that we could dismiss. So that would be my position and request of the court this morning. Thank you.
You said a couple of weeks.
I don't think I'll need long to either get an idea if Florida's still working on it and that's the avenue they want to pursue, or if they're going to not seek the extradition. So
You'll have to come back one more time, sir, at least.
That would be great.
How long is the estimate? Just a couple of weeks.
No, we're living in Utah. We're sitting on vacation. 798, 2630.
Was that for 29 feet of the
The Trump administration serves the devil. I am
Can you
God's
keep your
brother.
voice down, please?
Trump administration serves the devil.
Sir.
There's a bunch of devil worshippers in here, including all the police officers.
Sir, I'm going to ask to have you removed from the
That'll be just fine.
box. You need to keep your voice down.
Devil, and there's a bunch of devil worshippers in here. If you don't understand what that means,
Sir,
most of you do. Have a great day.
you need to keep it quiet.
Okay,
Only talk to your lawyer. If not,
that's not my lawyer. I represent myself.
you need to keep it down.
Okay, but that's not my lawyer. That's okay.
You're not going to keep it on the murder.
That's fine.
You want to go?
Sure.
Yes, that is.
Say like this. That's for you, everyone.
was that June
I'll
9th?
give you a setting, sir.
Yes, they put it in.
Damn, whatever happened to Flamingos, it wasn't me. Or maybe it was. Have a great day, everyone.
Sorry, Your Honor.
Sorry, Your Honor. Sorry. Martha, breathe through this next one, okay, hon? Just breathe through it. You'll be fine.
The court's going to open the record in 25 CR 52. I note the appearance of Mr. Bullock on behalf of the people. I have David Whitrock present today in person with Mr. Emmons, and we're set for a sentencing hearing. Mr. Emmons, are you prepared to proceed to sentencing?
I am, Judge. Thank you.
Did you have any additions or corrections to the pre-sentence investigation report? And Mr. Bullock, are you prepared to proceed as well?
I am.
All right, so I'll start with the people.
Judge, this was a stipulated plea to a drug felony for sentence being probation, open terms and conditions. The pre-sentence investigation showed Mr. Whitrock's LSI score of 30, placing him in the high risk of reoffending. The further review of the pre-sentence investigation shows that the recommendations concerning the court's sentence to probation, I would have no objection. I would ask the court to adopt those recommendations as its terms and conditions of probation. Nothing further in regards to the sentencing.
Thank you. Mr. Emmons?
Judge, I appreciate the court calling this late. Mr. Whitrock did try to contact my office yesterday evening. but I didn't get the message till today, so he wasn't sure what his court time was. So we're ready to proceed. I would ask the court to sentence Mr. Whitrock to probation. Mr. Whitrock doesn't have a really bad record. There's one thing that stands out, but that was when Mr. Whitrock, I think, was still a teenager or a very young man. 45 years ago, there was a robbery charge, or I can't tell. It seems like it might be motor vehicle theft, more like, but, and then he had a conviction for possession of a weapon, I think back in 2015, but that's more of a status offense. It didn't seem like anything else nefarious was going on there. Otherwise, he has a fairly minimal record. Mr. Whitrock is dealing with health issues. If the court may recall, there was a period of time when Mr. Whitrock was in the ICU for, well, he could address it better than I could, but I think it was congestive heart failure. So he's dealing with health issues. He does have a strong relationship with his partner. He's been with her for 27 years, I think. 29 years. Mr. Whitrock, this situation occurred about a year ago or more, and Mr. Whitrock hasn't picked up any other cases. He's been compliant with the court during the court proceedings in this case. And the probation department notes that a sentence to DOC in this case would be, in fact, totally counterproductive. So I would ask the court to give Mr. Whitrock a shot at probation, and I believe he'll comply with what he needs to do.
Thank you, Mr. Whitrock. You also have the opportunity to address the court your right of allocution. Would you like to make a statement?
I can't think of anything to say right now.
Okay, thank you, Mr. Whitrock. The court on this record has reviewed the pre-sentence investigation report. I've considered the statements of the parties. I've considered the purposes of the code with respect to sentencing as outlined in 18.1.102.5. The court is going to approve the plea agreement and accept it. The court does believe, based on the pre-sentence investigation report, that a term of probation is appropriate. Mr. Whitrock does have an LSI score of 30. That does put him in a high-risk level. However, that is still within the range where appropriate correctional interventions can be made and can have the most impact to reduce recidivism. And the court believes that treatment can be and is available in a community setting. So the court is going to sentence Mr. Whitrock to 2 years of supervised probation. I'm going to order Mr. Whitrock that you comply with all standard terms and conditions of probation, and I'm going to adopt the additional conditions of probation as recommended in the pre-sentence investigation report. That is, that you shall complete a substance abuse evaluation and comply with any recommended treatment. That may include outpatient, residential, intensive residential, or therapeutic community programs, MAT services, or prescription medications at probation's discretion. I'm also going to order that you complete a cognitive behavioral therapy program such as MRT, that you complete a random monitor substance testing, that you not consume alcohol or any illicit substances, that you obey all protection orders, that you complete 48 hours of useful public service, that you complete a fentanyl education program as a condition of probation, and the court is going to enter a prohibition of medical marijuana based on the information contained in the material evidence related to the use of medical marijuana section, but also to further the treatment goals in this matter. So there won't be any marijuana use allowed, including medical marijuana. Do you understand each of those orders?
I understand them. I don't agree with the medical marijuana part. I mean, unless you want me back on Vicodin and Oxycontins again for my back.
Well, you'll need to address that with probation, and you'll need to address that with your medical provider as well for any other alternatives that may be available. I'm going to grant to you 2 days of pre-sentence confinement credit. I'm going to order the fine of $1,000 be suspended, but I am going to impose all other fees and court costs, including the probation supervision fee. The fine will be suspended on the condition that you successfully comply with all terms and conditions of probation. I'm going to make a finding that there is no restitution as no victim has suffered any pecuniary loss. Court is going to continue the mandatory protection order in effect that will stay active throughout the sentence. And per the parties' agreement, I will dismiss the remaining counts, counts 1, 2, and 3. Is there anything additional for the sentence order, Mr. Bullock?
So yesterday we had no McDonald's. Today, no weed. You can't have any weed at all. Boy, they're taking away everything from everybody, guys.
D970, people of the state of Colorado versus Sandra Davenport. Ms. Davenport, are you here?
Yes, Your Honor.
All right, come on up.
Yes, sir.
You're good. Take a deep breath.
Yeah, nervous.
It's over. You're good.
Tired and nervous.
All right, it's okay. Your hair and your headphones match. It's not bad. It's not as bad as you think.
Right. It's not, right.
All right, let me check in with Mr. Brewer, see what I can do for you guys, all right?
Okay.
Mr. Brewer, what can I do for the parties today?
Ms. Davenport explained the reason why she missed her court appearance yesterday. It appears to be just a mix-up on the scheduling. The people would be asking that the warrant be quashed in this case, and we would ask for a continuance to a date after June 16th. Ms. Davenport has begun the classes that were agreed to for the case, and she just needs to complete 5 more. The termination date is June 16th.
Okay, Ms. Davenport, is that all accurate?
Yes, Your Honor.
Okay.
It is. I provided proof. I have proof.
Okay. I believe you.
Thank you.
I appreciate you being here. When people show up the next day, it's almost always a sign that they just made a mistake about the date.
Right.
Either the date they were supposed to be there or what day it actually was.
Right.
So I want to ask, do you get text message reminders of the court dates?
Yes, Your Honor.
All right. Pay close attention to those, as those will help you figure out which day you need to be there. I'm going to go ahead and quash the warrant. I'm going to reinstate.
Thank you.
You're welcome.
So there's no warrant.
There won't be once my clerk enters the correct codes and unchecks certain boxes.
Okay.
So there'll be no warrant by the time you walk out of here.
I can walk out of here?
When you walk out of here.
Okay.
You can't walk out of here yet.
Okay.
So, Ms. Davenport, I'm going to reinstate your personal recognizance bond, which means you won't go into custody. You won't have to post any money to get out. But if you don't show up for court, you'll owe the court $5,000. Court doesn't want your money. It just wants your attendance.
Right.
It's a simple trade. You show up, you don't owe the court money. You don't show up, you owe the court money.
Right.
So because you're taking this class, we're going to find a new date for you after June 16th in Division 404. That's your home division. You've made all of your other appearances from what I can tell, which is great. And that definitely reinforces that this was just a mistake.
Yes, Your Honor.
All right. Any scheduling issues we should know about for you before we offer you a new date?
No, Your Honor.
And would you like a written reminder once the date's set?
Yes, Your Honor.
All right. When can 404 have Ms. Davenport back?
June 29th at 8:30.
That's a Monday. Ms. Davenport, does that work for you?
Yes, Your Honor.
Mr. Brewer?
It works.
Okay. Anything else for the prosecution?
No, Your Honor. Thank you.
Anything else for you, Ms. Davenport?
Thank you.
You're welcome. So we'll bring out the written reminder. Once you have it and you walk out the door, the warrant is quashed, you're back on your bond, and you'll just need to be back on June 29th. Hopefully you'll have completed those classes and gotten proof back to the district attorney.
Yes, Your Honor.
All right. Thank you very much.
Thank you.
You're welcome. Take care.
So I ended on everything went good for her, even though she was literally terrified to be there because we had so much crazy today. Today was all about insanity. Someone saying she just missed her court date yesterday and came in the next day. Thought she was going to go to jail. She didn't. Love, people miss their court dates for 8 years and they don't go to jail. So you were fine. You worried over nothing. Doesn't help to worry about things, guys. It just doesn't help. It's either going to go bad or good. Doesn't help to worry about it, right? Just watch court videos, and then you don't have to worry about nothing. All right. Thank you for coming out today, guys. I appreciate it. I really do. Saturday morning, I'll see you in 22 hours-ish. Give or take 5 minutes here or there. 5 minutes between friends. I hope that you guys have a great, great, great Friday. And get ready for the weekend. Remember, it's Friday, so do not get arrested today. Yeah, I'm talking. All right, you got a problem with that? My cat hates when I talk. It's Friday. Don't get arrested today because there's no judge till Monday. Wait until Sunday night to do whatever you're thinking of doing. Or don't do it at all. I should have said that. That's what I should have said. No, wait till Sunday night. I hope that you guys have a great day. Love you too. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.